Now, Judge, I'll be honest with you. I've talked to Miss Barnett also and said, you got a new judge on, you got a new marshal sitting in that black chair there. Okay. And I'm not so sure what he's going to do.
Okay. Calling case 23002722, People versus Emily Barnett. We're here for pre-trial appearances, please.
Good afternoon, Your Honor. Tina Moynihan on behalf of the people, P84692.
Good morning. Counsel, please, you and your client's name.
Good afternoon, Your Honor. Wyatt Harris, P54891, on behalf of Barnett, who appears via Zoom, is unmute your phone and give your name.
Barnett.
Thank you, counsel. Thank you, Ms. Barnett. Good afternoon, everyone. We're here today for, looks like a pre-trial. Do we know the date of trial set on this matter?
Set for July 29th, Judge.
Okay. Counsel, where are we at on this matter, or where discussions have taken place, or what's the status on this?
Yeah, I still need to have, go ahead. Go ahead, Madam Prosecutor.
Sorry, Mr. Harris. There's been a lot of back and forth with regards to the issue of bond with a recent order from the Court of Appeals. That's since been finished and wrapped up. Mr. Harris is also relatively new to the case as well. He came in at the time that the appeal was filed in the Court of Appeals for the bond issue. So there's not been a lot of progress moving forward up until this point. I can let the court know that there was an offer conveyed to Mr. Harris as well as prior counsel, that being for Ms. Barnett to plead guilty to count 2, the reckless driving causing death, with a sentence agreement of 5 to 15 years in the Michigan Department of Corrections. I am still open to negotiations. The prior judge did not set any motion dates as far as like a motion to quash or anything that may need to be filed by defense. So I don't know if that's something that this court would like to do at this time, but that's, I believe, about as far as we've gotten up to this time.
All right, thank you, prosecutor. Defense counsel, any response on that, or I'm assuming you want to continue working on this?
Yes, I want to continue working on it, Your Honor.
Okay, let's get a date on the books for at least any motions. I don't know if the calendar conference was done with all the dates, or we just set a trial date. Okay, so let's, Mr. Harris, how long do you feel you need? You have a July trial date. How long do you feel you need for any potential motions or anything?
Why don't we set it for like the beginning of March, Your Honor, for when motions would be due?
Okay, we'll give you a March date.
And obviously a March motion date.
March 12th.
That would be the date for any motion hearing? Yes. Okay, so how about we go a little further? This way we can give them March 12th as the date to have anything submitted for both prosecution and, well, for at least for defense counsel. Probably 2, so I can give prosecution time to respond.
Okay. March 29th.
All right, Mr. Harris, the court's going to set March 29th as the date for the motions to be heard. If you could submit your motion by the 12th, this way, by March 12th, this way prosecution will have another 2 weeks to file any response, and then we'll be within time to hear the motions on the 29th.
Okay.
Clear for everyone? So March 29th will be our motion date. Defense will submit any motion by March 12th or sooner. And then prosecution, you'll have 2 weeks from time of submission to file a response.
And Judge, if I may, I'm planning to be out of town the week of the 25th, so I wouldn't be back on the 29th. Okay. Are we able to just push it to that Monday being April 1st?
That's fine.
Thank you, Judge.
All right, Mr. Harris, we're going to change the motion date to April 1st just because prosecution won't be here.
Okay.
So it's only a few days past, all right? But we'll leave the date due for everything to say by March 12th for you, okay?
Perfect.
All right. Prosecution, anything further with regard to bond or motion or anything that would?
No, Judge, thank you.
Mr. Harris, the court's going to address bond on its own just because there's been some new information presented. I'll give you an opportunity to. April 1st is a Sunday?
It's a Monday, Judge. It's a Monday.
Okay. All right, Mr. Harris, the reason the court is has concerns regarding bond is Ms. Barnett has been out on bond. I know there's been some addressing of bond prior, but the court's been advised that there's been a new June 19th, 2023 case out of Ecorse Police Department. Prosecution, can you provide any information regarding that new case or cases?
Judge, those cases were already addressed with regards to bond and the motions that I filed previously. There was an Ecorse incident, and I apologize, I don't have the dates in front of me specifically. But there was an Ecorse incident in which Ecorse Police Department had not removed the lien entry with regards to the vehicle that was used in the homicide case being a wanted vehicle. That vehicle was spotted first via a flock system for license plate readers. That vehicle was then stopped by Ecorse Police Department. At the point that the vehicle had been stopped, there was a passenger in the back seat of the vehicle who took off running. Officers saw a stopping motion in the vehicle, and then as that individual is running, there was another individual in the same area who was assisting that person to flee the location, and shots were fired at the officers who were pursuing the initial suspect who took off out of that vehicle. Ms. Barnett was the driver of that vehicle. And upon a search of the vehicle, there was alcohol found inside, and she was charged with open intox. And the issue of her driving while on a bond that precludes her from driving was raised with the court after that incident had been charged.
All right, and then there's a second charge of an ID theft, which is a felony?
That is correct, Judge. That case is still pending in Romulus at the 34th District Court. That is set for exam on January 17th, it appears. There was an allegation by the complainant in that case of a hotel purchase being used on his credit card, and that was also addressed with the court previously.
All right, thank you. Defense Counsel Harris, any input on bond there? And I'll just be upfront with you. The concern is the charge itself has a high likelihood of prison time, even considering the offer of one felony would lead Ms. Barnett to potentially have 5 years prison time. And more concerning than even the original charge, she still is presumed innocent, is we have a new case while she's out on bond. So I don't know how that was addressed previously, but we have to reassess it. She has a drinking related offense while out on bond on this case.
Your Honor, let me indicate to you, she has an appellate lawyer who addressed all of those issues. The reason I do not do my appeals, and so that appellate lawyer was assigned to her case, and we argued, she argued, I did not argue, I listened. She argued all those points in front of the previous judge. If you would like to address bond, I'd feel more comfortable having this appellate lawyer appear because she truly understands what's going on. She filed the appeal. She knows what's going on. Ms. Barnett clearly understands that she is not to pick up any cases or new cases while out on bond, and understands that it truly, because of these two, because of this experience with the court of, with your court, with your previous predecessor and the Court of Appeals, she truly understands that there will be, that they've addressed her bond, and fortunate for her, she's out. Now, Judge, I'll be honest with you. I've talked to Ms. Barnett also and said, you got a new judge on, you got a new marshal sitting in that black chair there, okay? And I'm not so sure what he's going to do, But I would ask this court, if you truly want to address bond, let's set a bond hearing date where her appellate lawyer can make the argument, because she's much more advised and educated about this particular situation because she wrote the appeal.
All right, understood. Thank you for that input, Defense Counsel Harris. Is your client employed? What is she doing?
Ms. Barnett, would you explain to the court what your situation is in terms of employment?
Okay, hi, Judge. I do work at WC3, Wayne County Community College as well, and I give it back to the community for eCourse community as well. And I can advise that with employment and verification as well. I've been advised for employment since August for Wayne County Community College in Taylor.
Ms. Barnett, what do you do for Wayne County Community College? And when do you work?
I work Monday through Saturday, 6 days a week, 3 to 11. I clean up the college, the classrooms, and the break rooms and the bathrooms as well. And I have documentation as well.
And what is the volunteer work you do for eCourse?
Okay, I give back coats, and then I'm in the fund giving back coats, food drive as well, and I'm doing an election in February as well for the city council.
Thank you.
All right, counsel, I'm going to review some factors, and just to be thorough here, I think part of the issue prior was, things may have not been explained thoroughly, or the factors. I know that there was a review, or the Court of Appeals sent it back to be reviewed under the factors, and I know that was probably done, but the court has some serious concern, and following, just so you have a reference, under Michigan Court Rule 6.106 F1, which provides some factors for the court to consider in bond, and specifically small e says the seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence. Based even upon the allegations in this case and someone being deceased, I don't think we could have any more serious or high level of concern for the public. Also, the probability of conviction and likely sentence, on the one in felony count one, it's a possibility of 18 years. Felony 2 would be 3.5 to 7. The current offer has been proposed as plea to count 2, and with the dismissal of the highest felony, she still would face a 5-year to 15-year prison punishment or potential 5-year prison penalty. Looking at factor I, any other facts bearing on the risk of non-appearance, I know she's been cooperative and appearing in court, so the court will consider that and honor that, but it also provides or danger to the public. This court has very serious concerns about safety of the public. One, a few months after this case, there's allegations that Ms. Barnett picked up a new case in eCourse on June 19th, 2023, with allegations of other people having firearms. There's an open intox charge that she's currently charged with, which has very serious concerns for the court of alcohol being involved in the current case pending, where we have a person who is unfortunately deceased. So that covers element I. Also, the protection of the public and the seriousness of the offense charged. This court is definitely going to modify bond. What we'll do, Mr. Harris, is we'll set a secondary review date where the appellate attorney is permissible to address this at any time, as the court is permissible to address bond at any time. But based upon the seriousness of this case, based upon the lack of conformity with the prior bond, that being the open intox case, and also to add to that, Ms. Barnett has a felony ID theft case that is also pending. So there's too much going on here to simply keep a personal bond or allow Ms. Barnett to just roam free. So based upon those factors and the protection of the public, the court is going to modify bond to $250,000 cash or surety. The court is also going to impose a GPS tether. You know, Mr. Harris, I always give deference to a defendant. I mean, that's just how I am, but there's just too much here, and the seriousness of the pending charge, and with someone, you know, unfortunately being deceased, it's too much on the table to have Ms. Barnett just out on a personal bond. And if you presented Mr. Harris with, she's done absolutely nothing and she's complied and everything, but that's not the case. She has an open intox case. There's allegations of firearms being in the vehicle that she was in, and there's a felony ID theft case. So the factors and the concern for the safety of the public are too great for this court in good conscience to leave bond as it is. So that'll be the order of the court. Can we give a, maybe like a 2-week review date so the Court of Appeal or appellate attorney can have the opportunity to appear and address that?
January the 29th.
We'll have a January 29th secondary review date. That'll just be a courtesy, just be based upon the statements of defense counsel Harris that there is a second counsel in this matter. So again, to give every opportunity to Ms. Barnett to have due process another time around, we'll have that secondary date.
Your Honor, would you allow Ms. Barnett to turn herself in on Monday?
Absolutely not. No, Mr. Harris, it's too much. No, it'll be a turn in today. All right.
Okay, thank you very much, Your Honor.
All right.
And Judge, if I may, what was the return date for the bond? I'm sorry.
January 29th.
Thank you.
All right, this matter is concluded.
I gotta turn myself in.
Ms. Barnett, I'll call you.
Cash surety.
Ms. Barnett, log off right now. I'll call you.
No 10%?
No.
Ms. Barnett, log off right now. Ms. Barnett, log off right now, please.